Good morning to all of you. I hope all of you are doing great. So let's start today's discussion. आज हम लोग बात करने वाले हैं 2018 की शिफ्ट 1 के एमपी सिविल जज प्रीलिम्स के क्वेश्चन पेपर के बारे में, जिसमें आज हम लोग कॉन्स्टिट्यूशन ऑफ इंडिया, सीपीसी और कुछ क्वेश्चंस ट्रांसफर ऑफ प्रॉपर्टी एक्ट से कलेक्ट करने वाले हैं। ये जो आपका पर्टिकुलर एग्जाम था, ये आपका 24/9/2018 में कंडक्ट हुआ था और इस पर्टिकुलर एग्जाम के अगर मैं कट ऑफ की बात करूं तो इसका कट ऑफ था 121 मार्क्स out of 150. So let's start today's discussion. If you people haven't subscribed to our channel till now, please go and subscribe to the channel and don't forget to press the bell icon so that whenever me or any of the faculty members are coming live, you will get the notification of the same. Now, apart from this thing, if you people haven't checked out MP Civil Judge Prelims crash course, link is in the description box below. Do check it out. In this, you are getting 10 plus mocks, one-on-one mentoring and doubt clearing sessions, recorded video lectures, and much more. So let's start today's discussion. The first question for today is, which of the following is not a constitutional body? The question is, which of the following is not a constitutional body? So here you have to remember that they have started the statement with the word not. So which of the following is not a constitutional body? Your options are A, Election Commission, B, Niti Aayog, C, GST Council, and D, Interstate Council. Election Commission, Niti Aayog, GST Council, and Interstate Council. What should be the correct answer? If you people can observe this particular question closely, तो यहाँ पे आपसे ये पूछा गया है कि निम्नलिखित में से कौन जो संवैधानिक बॉडी नहीं है या संवैधानिक संस्था नहीं है। आपके ऑप्शंस हैं इलेक्शन कमीशन, नीति आयोग, जीएसटी काउंसिल और इंटरस्टेट काउंसिल। तो इसका करेक्ट आंसर होगा बी फॉर बैंगलोर, दैट इज नीति आयोग। नीति आयोग मींस नेशनल इंस्टीट्यूट फॉर ट्रांसफॉर्मिंग इंडिया। ये प्लानिंग कमीशन को बाद में चेंज करके एनडीए गवर्नमेंट ने, बीजेपी गवर्नमेंट ने नीति आयोग बनाया, एंड दिस पर्टिकुलर ऑर्गेनाइजेशन is not a constitutional body. So its correct answer will be Niti Aayog. चलिए next question, question number 2. Under Indian Constitution, fundamental duties enshrined under Article 51A does not include the duty A, option A, to uphold and protect sovereignty of India. Option B, to defend the country when called upon to do so. Option C, to preserve and value rich heritage of our composite culture, and option D, to protect monument places and objects of national importance. तो यहाँ पे अगेन हमसे ये पूछा गया है कि which of the following is not a fundamental duty, rather than ये क्वेश्चन पुट किया जाए कि कौन सी फंडामेंटल ड्यूटी है, हमसे ये पूछा गया है कि कौन सी फंडामेंटल ड्यूटी नहीं है, राइट। तो आपके जो ऑप्शंस हैं, पहला है to uphold and protect sovereignty of India. Option B, to defend the country when called upon to do so. Option C, to value and preserve rich heritage of our composite culture. And option D, to protect monuments, places and objects of national importance. अब अगर आप लोग आर्टिकल 51A को पढ़ेंगे तो all these A, B and C, all these three are fundamental duties, but the option D, that is not a fundamental duty, that is directive principle of state policy under your article 49. So its correct answer will be D for Delhi, that is to protect monuments, places and objects of national importance, right? Chaliye next question, question number 3. It is again from Constitution of India. Ujjwal Nahar, can you explain question 1 again? Ujjwal ji. Okay Ujjwal ji, I can explain question number 1 again. Question number 1 was stating which of the following is not a constitutional body, and the options were Election Commission, Niti Aayog, GST Council and Interstate Council. So except Niti Aayog, that is National Institute for Transforming India, rest other are your constitutional bodies. So its correct answer will be B for Bangalore, Ujjwal ji. Now question number 3, Constitution of India. The right to vote in India is, the right to vote in India is, option A, fundamental right, option B, natural right, option C, constitutional right, and option D, legal right. So question number 3, Constitution of India से है, the right to vote is a fundamental right, natural right, constitutional right and legal right. So its correct answer will be your D for Delhi, that is legal right. अब ये चीज, ये पर्टिकुलर क्वेश्चन का आंसर यू विल नॉट फाइंड इन द कॉन्स्टिट्यूशन ऑफ इंडिया. अगर आप सेक्शन 62 पढ़ते हैं रिप्रेजेंटेशन ऑफ पीपल्स एक्ट 1961 का, तो उसमें ये चीज क्लियरली मेंशन्ड है. किसमें? रिप्रेजेंटेशन ऑफ पीपल्स एक्ट 1961 में, दैट राइट टू वोट इज अ लीगल राइट. सो इट इज नॉट अ फंडामेंटल, नेचुरल और कॉन्स्टिट्यूशनल राइट, राइट. लेकिन इवन सुप्रीम कोर्ट ऑफ इंडिया अंडर द इंटरप्रिटेशन ऑफ आर्टिकल 21 कई सारे केसेस में सुप्रीम कोर्ट ऑफ इंडिया ने इसको इंटरप्रेट किया है. सो it doesn't mean it is going to become a fundamental right. It is only remaining as a legal right. Question number 4. Question number 4 क्या बोल रहा है? Which of the following is true and correct regarding Article 14 of the Constitution of India? Which of the following is correct and true regarding Article 14 of Constitution of India? Option A, it forbids class legislation. Option B, it allows reasonable classification. Option C, both it forbids class legislation and allows reasonable classification. And option D, none of the above, right? So if you will follow up this particular question closely, if you read Article 14, it is having two types of things, that is equal protection of law and equality before law and equal protection of law. तो जो इक्वालिटी बिफोर लॉ है, इट फॉरबिड्स द क्लास लेजिस्लेशन, एंड इक्वल प्रोटेक्शन ऑफ लॉ इज टॉकिंग अबाउट रीजनेबल क्लासिफिकेशन. सो बोथ ऑफ दीज आइडियाज आर एनश्राइंड इन द कॉन्स्टिट्यूशन ऑफ इंडिया. सो इट्स करेक्ट आंसर विल बी सी फॉर कैलकाटा, दैट इज both it forbids class legislation and allows reasonable classification. Yes, Ankita Gupta ji, fourth ka C is the correct answer. You are correct. Now question number 5. Which of the following article of the Constitution of India recognizes the doctrine of double jeopardy? Which of the following article of, yes, Ujjwal Nahar ji, fourth ka C is the correct answer. Question number 5. Which of the following article of the Constitution of India recognizes the doctrine of double jeopardy? Double jeopardy means no person can be prosecuted and punished twice for the same offense. Your options are option A, sir, but question for question 3 answer will be constitutional right. For which particular question you are stating? Ujjwal ji, question number 3. Now I will suggest you, if you are if you are not having the Bare Act, you can just check the Bare Act of Representation of People Act and try to read section 62 of that particular act, and you will get the answer, right? Its answer is legal right, not a constitutional right, right? Now question number 5. So which of the following article of Indian Constitution recognizes the doctrine of double jeopardy? Article 22 subclause 2, Article 20 subclause 2, option 21 subclause 2, and D is none of these. So its correct answer will be your option C, that is Article 20 subclause 2. Article 20 subclause 2, right? Next, question number 6. Constitution of Panchayats is given under, right? Constitution of Panchayats is given under dash 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 of the Constitution of India. Constitution of Panchayat is given under dash 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 of Constitution of India. ठीक है, इसको नहीं देखना है, it is not important, right? So it should not be considered, it is typo. So the Constitution of Panchayat is given in the Constitution of India. Option A, Article 243B. Option B, Article 243O. Option C, Article 243W. And option D, Article 243A. So what should be the correct answer for question number 6? Yes, the Constitution of Panchayat, formation of Panchayat, is given under which of the following article? So its correct answer will be your Article 243B. Article 243B of Indian Constitution talks about Constitution of Panchayats, right? So its correct answer will be no, Jwal Naharji, it will not be D, it will be B, right? Not A, right? 243B is talking about Constitution of Panchayats, right? Question number 7, again from Constitution of India. Yes, Ankita Gupta ji, 6th ka B will not be the correct answer, A is the correct answer, right? Now, Question number 7. The Constitution of India. Protection and improvement of environment and safeguarding forest and wildlife is. Protection and improvement of environment and safeguarding forest and wildlife is. Option A, one of the fundamental duties. Option B, one of the directive principle of the state policy है जिसको हम DPSP भी बोलते हैं. Option C, both directive principle of the state policy and fundamental duty. And D, none of these. Question number 7. Protection and improvement of environment and safeguarding the forest and wildlife is fundamental duty, directive principle of the state policy, both fundamental duty and directive principle of the state policy, and none of the above or none of these. So what should be the correct answer for question number 7? Yes. क्या होगा question number 7 का correct answer? जल्दी से बताइए. Its correct answer will be C for Calcutta. That is both. It is directive principle of the state policy as well as it is a fundamental duty, right? Nahi Ujjwal Nahar ji, its answer will not be 7th ka will not be B. Its correct answer will be C, because if you will read Article 41A of Indian Constitution, it is also talking about as fundamental duty to protect and conserve the environment, right? Question number 8. Which among the following is not a fundamental right according to Constitution of India, right? Which among the following is not a fundamental right under Constitution of India? चिया एन जी 7th का बी बोल रहे हैं. नहीं, 7th का सी होगा. देखिए मैं आपको स्पेसिफिकली प्रोविजन बता सकता हूं. अगर आप आर्टिकल 48A पढ़ते हैं और साथ ही साथ आप आर्टिकल 51A क्लॉज जी पढ़ते हैं, तो आर्टिकल आपका 48A and 51A clause G is talking about both of these are talking about protection of environment and wildlife. One is under the directive principle of the state policy, another one is under the fundamental duties, right? Question number 8. Which among the following is not a fundamental duty according to the Constitution of India? Option A, right to equality. Option B, right to freedom of religion. Option C, right to constitutional remedies. And option D, equal justice and free legal aid. यहाँ पे आपको याद क्या रखना है? हमसे ये पूछा गया which of the following is not a fundamental right. हमसे ये नहीं पूछा गया कि कौन सा फंडामेंटल राइट है, हमसे ये पूछा गया कौन सा फंडामेंटल राइट नहीं है. सो ऑप्शन A, B and C. Option B, only A. Option C, only D. And option D, only B. They are giving you the codes, और हिंदी में जिनको हम बोलते हैं कूट. Question number 8 is a code based question, right? So which of the following is not a fundamental right? Now here you have to remember that yes, right to equality is a fundamental right. Right to freedom of religion is a fundamental right. Right to constitutional remedies is a fundamental right. But equal justice and free legal aid is not a fundamental right. So its correct answer will be C. C for Calcutta, right? याद रखिएगा इस चीज को, because equal justice and free legal aid, this particular thing is simply stating about what? It is simply stating about directive principle of state policy. Next question, question number 9. The Constitution of India. Which of the following is not a directive principle of state policy? Which of the following is not a directive principle of the state policy, right? So option A, organization of village panchayats. Option B, uniform civil code for citizens and non-citizens. Option C, right to work, comma, to education and to public assistance in certain areas. And option D, separation of judiciary from executive. Yes, Ankita Gupta ji, 8th ka C is the correct answer. Ujjwal Nahar ji, 8th ka C is the correct answer. Question number 9. The Constitution of India. Which one of the following is not a directive principle of the state policy? Option A, organization of village panchayats. Option B, uniform civil code for citizens and non-citizens. Option C, right to work, to education and to public assistance in certain cases. And option D, separation of judiciary from executive. So what should be the correct answer? Organization of village panchayat, uniform civil code for citizens and non-citizens, right to work, to education and to public assistance in certain cases, and D, separation of judiciary from executive. Now, yes, Chia NG, it's correct. 8th ka correct answer will be A. Ninth, its correct answer will be B for Bangalore, right? No, Ujjwal Nahar ji, ninth का A नहीं होगा, ninth का B will be the correct answer because organization of village panchayats is a part of your fundamental duty. Directive principle of the state policy. So its correct answer will be your option B. The reason behind, because here they have used the word, if you can closely follow up, they have used the word citizens and non-citizens. So uniform civil code for both citizens and non-citizens. नहीं अंकिता गुप्ता जी, A नहीं होगा. Try to read. They have tried to manipulate the students with the option. अगर आप बी ऑप्शन पढ़ेंगे तो इट इज टॉकिंग अबाउट यूनिफॉर्म सिविल कोड फॉर सिटीजंस एंड नॉन सिटीजंस बोथ, बट your article 44 is talking about uniform civil code for citizens, but it is not talking about uniform civil code for non-citizens. So its correct answer will be B for Bangalore. I hope it is clear. Question number 10. The preamble of the Constitution of India, the people of India have resolved to constitute India into. ये डायरेक्टली प्रियम्बल की लैंग्वेज से है. क्वेश्चन नंबर 10. इन द प्रियम्बल ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया द पीपल ऑफ इंडिया हैव रिजॉल्व टू कॉन्स्टिट्यूट इंडिया इनटू. ऑप्शन ए सोवरेन डेमोक्रेटिक रिपब्लिक. सर मेरा एक क्वेश्चन है, मैंने 4 ईयर यूपीएससी की तैयारी की है, बहुत मेहनत की है, मुझे पीसीएस एग्जाम देना चाहिए या जुडिशरी के लिए. जाहिद सैफी जी. Zahid ji, is it okay if I will take up your doubt like after the end of this session, because that will be fruitful for you as well as for the others. I hope I am quite clear that I am going to take up your doubt after this session, right Zahid ji? Now, in the preamble of Constitution of India, the people of India have resolved to constitute India into. Option A, sovereign democratic republic. Option B, sovereign socialist democratic republic. Option C, sovereign socialist secular democratic republic. And option D, sovereign secular democratic republic. So what should be the correct answer? Question number 10. Yes, its correct answer will be C for Calcutta, that is sovereign socialist secular democratic and republic. Here you have to remember that these two words socialist and secular have been added by 42nd amendment. Yes, 10th ka Ujjwal Nahar ji, C is the correct answer, right? Now, let's move further with question number 11. Question number 11 is from CPC, that is Code of Civil Procedure. A decree for injunction. Ankita Gupta ji, 10th ka yes, C is the correct answer. Question number 11. A decree for injunction if not obeyed. A decree for injunction if not obeyed. A is not executable. Option B is executable by the detention of judgment debtor in civil prison or by attachment of his property. Option C is executable by filing a petition under Order 39 Rule 2A of CPC. And option D is executable by filing a fresh suit. Question number 11. What should be the correct answer? A decree for injunction if not obeyed. Option A is not executable. Option B is executable by detention of judgment debtor in the civil prison or by attachment of his property. Option C is executable by filing a petition under Order 39 Rule 2A of CPC. And option D is executable by filing a fresh suit. Question number 11. What should be the correct answer? Yes, just let me know. Question number 11. What should be the correct answer? A decree for injunction if not obeyed is not executable, is executable by detention of judgment debtor in civil prison or by attachment of his property. Option C is executable by filing a petition under Order 39 Rule 2A of CPC. And option D is executable by filing a fresh suit. So its correct answer will be your option B, that is executable by detention of judgment debtor in the civil prison or by attachment of his property. Now, Vinny ji, no, its correct answer will not be C. Its correct answer will be B. Now, if you will closely follow Order 32 Rule 21 of CPC, right? They are simply stating that a decree for injunction, if not obeyed, that can be followed up by the procedure of Order 38. And Order 38 क्या बोल रहा है? Attachment of the property of judgment debtor and civil prison to the judgment debtor, right? So its correct answer will be B. Yes, Ujjwal Nahar ji, it's B is the correct answer. Question number 12. A decree for restitution of conjugal right is executable. Question number 12. A decree for restitution of conjugal right is executable. Option A, by attachment of property or by detention in civil prison or by both. Option B, by attachment of property. Option C, by imprisonment. Option D, by granting a decree of divorce, right? A decree for restitution of conjugal rights is executable. Option A, by attachment of property or by detention in civil prison or by both. Option C, by attachment of property. Option B, by attachment of property. Option C, by imprisonment. And option D, by granting a decree for divorce. So question number 12, its correct answer will be by attachment of property. Now, I hope it is clear that it is simply stated for the restitution of conjugal rights, the decree can be executed only by attachment of property or attachment of salary, right? But not by the detention of the judgment debtor in the civil prison. So question number 12, B is the correct answer. No, Vinny ji, not by imprisonment. Yaad rakhiye, in the cases of restitution of conjugal right, there is no provision for imprisonment, right? 12A, no, it will not be A, it will be B, right? Ujjwal Nahar ji, it will be B. Question number 30. Which one of the following statement is incorrect regarding compromise under Order 23, Rule 3 of CPC? Ankita Gupta ji, it will not be A for 12th. 12th ka correct answer will be B. That is only by the attachment of property of judgment debtor. Question number 13. Which one of the following statement is incorrect regarding the compromise under Order 23, Rule 3 of CPC? Option A, must be in writing and signed by the parties. Option B, must be in writing and need not to be a lawful agreement. Option C, it is required that the subject matter of compromise is the same as the subject matter of suit. Option D, a compromise which is voidable under Indian Contract Act shall also be voidable within the meaning of this rule. So we have to find the incorrect statement, wrong statement over here. Yaad rakhiye, they are not asking what should be the correct statement. They are asking the incorrect statement. Yes, 13th ka C is the correct answer. That is, it is required that the subject matter of compromise is same as the subject matter of the suit. It is not, it is necessary. So it will be incorrect, right? So here option C is your correct answer, right? Next, question number 14. Where a suit is dismissed under Rule 8 of Order 9 of CPC. Where a suit is dismissed under Rule 8 of Order 9 of CPC. Order 9, Rule 8, right? In respect of the same cause of action, the plaintiff shall be precluded from bringing a fresh suit. B, may bring a fresh suit subject to law of limitation. C, may not apply to set aside the order of dismissal. D, may bring a fresh suit. Question number 14. What should be the correct answer? Now, Order 9, Rule 8. What are all options we are having? That shall be precluded from bringing a fresh suit. B, may bring a fresh suit subject to law of limitation. C, may not apply to set aside the dismissal order. And D, may bring a fresh suit. Sir, can you please explain question number 14? Ujjwal Nahar ji. Okay, I can explain it to you. Now, firstly, its correct answer will be A for Ahmedabad. That is, shall be precluded from bringing a fresh suit. Now, you have to understand that Order 9, Rule 8 is stating dismissal of suit in the cases of non-appearance of party. Now, Order 9 is talking about appearance and non-appearance of party, and Order 9, Rule 8 is stating where continuously the both of the parties the plaintiff doesn't appear and the defendant appears, right? In that case, what the court is going to do, the court is going to simply dismiss the suit. Now, under Order 9, Rule 9, it is simply stating that that particular party against whom that order of dismissal has been passed, that particular party, or I should say the plaintiff shall be precluded from bringing a fresh suit. But he is having the option to apply for the dismissal order, right? So he may apply for a dismissal order, but he cannot go for filing a fresh suit. I hope it is clear to you. Ujjwal Nahar ji, yes. Vinny ji, 14 ka A is the correct answer. Question number 15. A decision or finding given by court without. A decision or finding given by court without. Option A, can operate as res judicata under all circumstances. Option B, cannot operate as res judicata. Option C, can operate as res judicata under certain circumstances only to the jurisdiction. Option D, may operate as res judicata or may not operate as res judicata. So a decision or finding given by a court without jurisdiction. A decision or a finding given by a court without jurisdiction can operate as res judicata, cannot operate as res judicata. Yes. Option C, can operate as res judicata under certain circumstances only regarding jurisdiction. And D, may operate as res judicata or may not operate as res judicata. So question number 15, what should be the correct answer? Question number 15, a decision or, sir, question number 15 seems to be incomplete. Here you have to add the word jurisdiction. A decision or finding given by the court without jurisdiction. Here, I don't know I can write it or not. Let me just try to it. If I can write something, I'm just going to write that word. Here you have to write the word jurisdiction, right? Yes. So yes, this question seems to be incomplete, but here we have to write the word jurisdiction, right? Now, its correct answer will be B, that is, cannot operate as res judicata. Yes, Ujjwal Nahar ji, you are correct. Its correct answer will be cannot operate as res judicata. Question number 16. A suit for partition of properties situated in different cities. A suit for partition of properties situated in different cities. Option A, separate suit has to be filed in each of the cities where the properties are situated. Option B, can be instituted in a city where any property are situated. Option C, can be instituted in a city where majority of the property of maximum value is situated. Option D, can be situated where defendants or any of them reside. Question number 16. Question number 16. A suit for partition of property situated in different cities where the suit can be filed. Separate suit has to be filed in each of the cities. Option B, can be instituted in a city where any of the properties are situated. Option C, can be instituted in a city where majority of the properties or the property of maximum value is situated. And D, can be instituted where the defendants or any of them resides. Yes, its correct answer will be B. Vinny ji, you are correct. That can be instituted in a city where the property of where any of the property is situated. So this particular question is belonging to section 16 of your CPC. Yes, Ankita Gupta ji, you are correct. Question number 17. Under section 148 of CPC, the court can enlarge the time not exceeding in total. Question number 17. Under section 148 of CPC, the court cannot enlarge the time not exceeding in total. Option A, 90 days. Option B, 60 days. Option C, 45 days. And option D, 30 days. 90 days, 60 days, 45 days, 30 days. Question number 17. The court cannot enlarge the time exceeding in total. 90 days, 60 days, 45 days, and 30 days. So question number 17. Its correct answer will be yes. Question number 17. What should be the correct answer? Its correct answer is D, that is 30 days. Now here, some of you might get confused, right? Yes, Vinny ji, you are correct. Under section 148A, that is talking about right to lodge the caveat. A caveat shall remain valid for 90 days. So 148A के अंदर जो time period है, that is of 90 days. But under section 148, the court can enlarge the time in total not exceeding 30 days. So its answer will be D. Yes. Next, question number 18. A suit may be defeated due to. Order 1 से related है. Order 1 Rule 8 का question है ये. A suit may be defeated due to. Option A, non-joinder of property proper party. Option B, mis-joinder of necessary party. Option C, non-joinder of necessary party. And D, mis-joinder of proper party. Non-joinder of proper party, mis-joinder of necessary party, non-joinder of necessary party, and mis-joinder of proper party. So order 1 से related है. Question number 18, what should be the correct answer? A suit may be defeated due to non-joinder of proper party, mis-joinder of necessary party. Order 1 rule 1 का ही question है ये. Non-joinder of necessary party and mis-joinder of proper party. Yes, Vinny ji, you are correct. Its answer will be non-joinder of necessary party. Question number 18. C is the correct answer. Right? Ujjwal Nahar ji, nahi, B nahi hoga. Mis-joinder nahi. Non-joinder of necessary party. Here you have to understand, non-joinder means when a particular party was necessary to the suit as a plaintiff or defendant has not been added. And mis-joinder means someone who was not required to be added has been added. So its correct answer will be C. Question number 19. Again from CPC, suit against government shall not be instituted until the expiration of. Suit against the government shall not be instituted until the expiration of. Option A, 1 month notice, 1 month next after notice in writing has been delivered. Option B, 3 months after notice in writing has been delivered. Option C, 2 months after notice in writing has been delivered. And option D, 6 months after notice in writing has been delivered. So they are stating 1 month, 3 months, 2 months, and 6 months. Suit against government shall not be instituted until the expiration of. Suit against the government shall not be instituted until the expiration of. Section 79 का question है ये. Section 79 of CPC की language में सीधा सीधा mentioned है. So its correct answer will be C, that is 2 months after notice in writing has been delivered. 2 months after the notice in writing has been delivered, right? So its correct answer will be your option C. Now, Ujjwal Nahar ji answered B. Nahi, Ujjwal ji, iska answer B nahi hoga. In the cases of execution of decree against the government under section 82, there the time period is of 3 months. But under section 79, its time period is of 2 months. Yes, Ankita Gupta ji, you are correct. Question number 20. Principle of res judicata does not apply to. Principle of res judicata does not apply to. Option A, writ of habeas corpus. Option B, to interlocutory orders. Option C, to dismissal under order 17 rule 3. And option D, to ex-parte judgment. The principle of res judicata does not apply to. Option A, to writ of habeas corpus. Option B, to interlocutory orders. Option C, to dismissal under order 17 rule 3. And option D, to ex parte judgment. So question number 20, its correct answer will be A, to the writ of habeas corpus. Yes, Vinny ji, Ankita ji, both of you are correct for question number 19. For question number 20, correct answer will be A for Ahmedabad, that is the writ of habeas corpus. Now, next question, question number 21. Which of the following is not a right of civil nature? Option A, right to share in offerings in the temple. Option B, right to take out procession. Option C, right to worship in a temple. And option D, all of the above. Which of the following is a right of civil nature? Which of the following is a right of civil nature? Yes, Ankita Gupta ji, Ujjwal Nahar ji, both of you are correct. So, which of the following is a right of civil nature? Right to share in offerings in a temple. Option B, right to take out procession. Option C, right to worship in a temple. And option D, all of these. So its correct answer will be all of these. Which question you want me to explain again, Ankita ji? Just let me know. Its correct answer is all of these. Question number 21. Its correct answer will be all of these, because all of these are the right of civil nature, right? Yes. Ujjwal Nahar ji, you are correct. Ankita Gupta ji, its answer will be D. Question number 22. According to Order 20, Rule 7 of CPC, the decree shall bear the date of. Yes, Vinny ji, you are also correct. 21 ka D is the correct answer. According to Order 20, Rule 7 of CPC, the decree shall bear the date of the day on which the judgment was pronounced. Option B, the date on which the decree was made. Option C, the day on which the plaint was filed. And option D, the day on which final arguments was heard. Question number 20. Ankita ji, I am going to discuss this particular question after the class, right? So according to Order 20 Rule 7 of CPC, the decree shall bear the date of the day on which the judgment was pronounced, the day on which the decree was made. Option C, the day on which the plaint was filed. And option D, the day on which the final argument was heard. So question number 22, its correct answer will be A, that is the day on which the judgment was pronounced. The day on which judgment was pronounced, right? So I hope it is clear to all of you. Now, question number 23. Question number 22, yes, A is the correct answer, Viniji. Question number 23. Where a suit is abated or dismissed under Order 22 of CPC on the same cause of action. Where a suit has been abated or dismissed under Order 22 of CPC on the same cause of action. Option A, a fresh suit may be filed with the prior permission of court. Option B, no fresh suit shall be brought. Option C, new suit may be filed if sufficient cause is shown. Option D, new suit may be instituted with the consent of parties. Question number 23. Where a suit has been abated or dismissed under Order 22 of CPC on the same cause of action. Fresh suit may be filed, no fresh suit shall be brought. Fresh suit may be filed if sufficient cause is shown. New suit may be instituted with the consent of parties. 22 ka yes, Ujjwal Nahar ji, B is the correct answer. No fresh suit will be filed. Nahi, Vinny ji, its answer will not be A. Remember that कुछ चीजें आप लोग याद रखिए. Order 2 Rule 2, Order 9 Rule 9, Order 23 Rule 9. याद रखिए, Order 2 Rule 2, Order 9 Rule 9, Order 23 Rule 9. In 3 cases में you cannot file a fresh suit. You are barred to file a fresh suit. याद रखिए ये चीज. और ये क्वेश्चन एमपी सिविल जज में बहुत ज्यादा पूछे जाते हैं. ठीक है? So its correct answer will be no fresh suit shall be brought. Question number 24. The provision in respect of summary procedure has been laid down. The provision in respect of summary procedure has been laid down under option A, Order 32, Order 32A of CPC. Option B, Order 29 of CPC. Option C, Order 34 of CPC. And option D, Order 37 of CPC. 32A, 29, 37 and 34. Question number 24. What should be the correct answer? The provisions regarding summary proceeding. The provisions regarding summary proceeding. So they are provided under Order 37. Order 37 of CPC is talking about the provisions regarding summary proceeding. Right? Now, next question. Question number 25. Which provision order of CPC deals with production, impounding and returning of documents? Which provision order of CPC deals with production, impounding and returning of documents? Option A, Order 13 of CPC. Option B, Order 5 of CPC. Option C, Order 17 of CPC. And option D, Order 24 of CPC. 24 ka yes, Vinny ji, D is the correct answer. Question number 25. Which provision order of CPC deals with production, impounding and returning of documents? Option A, Order 13 of CPC. Option B, Order 5 of CPC. Option C, Order 17 of CPC. And option D, Order 24 of CPC. So its correct answer is option A, that is Ahmedabad. That is Order 13 of CPC. Yes, Ankita Gupta ji, 35. No, question number 25 ka correct answer is A. I think there is a typo from your end, Ankita. Yes, Vinny ji, A is the correct answer. Question number 26. The first question of Transfer of Property Act. Which one of the following statement is incorrect? Which one of the following statement is incorrect regarding transfer of immovable property by gift? Option A, instrument must be signed by or on behalf of donor. यहाँ पे हमसे इनकरेक्ट स्टेटमेंट पूछा गया है, याद रखिए. द इंस्ट्रूमेंट मस्ट बी साइंड बाय और ऑन बिहाफ ऑफ डोनर. ऑप्शन बी, इंस्ट्रूमेंट मस्ट बी साइंड बाय द डोनर ओनली. ऑप्शन सी, इंस्ट्रूमेंट मस्ट बी रजिस्टर्ड. Option D, instrument must be attested by at least 2 witnesses. Which one of the following statement is incorrect regarding transfer of property through a gift, right? Transfer of immovable property through a gift. So instrument must be signed by or on behalf of donor. Instrument must be signed by donor only. Option C, instrument must be registered. And option D, instrument must be attested by at least 2 witnesses. So question number 26, what should be the correct answer? Just let me know quickly what should be the correct answer for 26. Yes, I'm just waiting. Question number 26. Here, if you will read question number 26, there's a slight play with this question. That is, the whole game is depending on this word only. The whole game is depending on this word only. So its correct answer will be V. B for Bangalore. Yes, Vinny ji, you are correct, because instrument must be signed by donor or on behalf of donor and donee. And here they have used the word only, so its correct answer will be B for Bangalore, right? Next question, question number 27. The attestation of document means. The attestation of document means. Option A, the attesting witness is aware of the contents of the document. Option B, the attesting witness. Ankita Gupta ji, it will not be D, it will be B, right? Now, the attesting witness has seen the executant sign or affix his marks. Option C, received from executant a personal acknowledgement of his signature. Option D, both the attesting witnesses seen the executant sign or affix his marks and received from the executant a personal acknowledgement of his signature. Question number 27. Now, this particular question is derived from the definition clause of Transfer of Property Act. अगर आप section 3 पढ़ेंगे Transfer of Property Act का, तो you will be in the position to answer this question. So, the attestation of a document means the attesting witness is aware of the contents of the document. Option B, attesting witnesses seen the executant sign or affix marks. Option C, received from executant a personal acknowledgement of his signature. Option D, both attesting witnesses seen the executant sign or affix his marks and received from the executant a personal acknowledgement of his signature. Yes, 27 ka Ujjwal Nahar ji, D is the correct answer. You are correct. Now let's move towards next question. Question number 28. Transfer of property does not include. Transfer of property does not include. Option A, sale. Option B, lease. Option C, will. Option D, gift. Transfer of property does not include. Option A, sale. Option B, lease. Option C, will. Option D, gift. Sale, lease, will, gift. Which of the following is not included under Transfer of Property Act? Now, if you people are going to follow up like section 54, 55, 56, 57, there you will get a clear idea that Transfer of Property Act is talking about sale. Section 107 is talking about lease. And section 123 onwards, they are talking about gift. But will is not included. So yes, Ujjwal Nahar ji, 28 ka C is the correct answer. Its correct answer will be will, right? Now, let's move further. Yes, Ankita ji, Vinny ji, all of you are correct. Next question, question number 29. The gift of future property is. The gift of future property is. Option A, valid. Option B, voidable. Option C, void. Option D, conditionally void. Gift of future property is valid, voidable, void, conditionally void. What should be the correct answer? The gift of future property. Valid, voidable, void, conditionally void. So its correct answer will be C for Calcutta, that is void. So the transfer of future property as a gift is void in nature. So question number 29, C is the correct answer. It is defined under section 124 of Transfer of Property Act, right? Now, next question and last question for the day. Which of the following section of Transfer of Property Act deals with the effect of holding over a lease? Which of the, yes, Viniji, 29, C is the correct answer. Which of the following section of Transfer of Property Act deals with the effect of holding over a lease? Which of the following section of Transfer of Property Act deals with the effect of holding over a lease? Option A, section 115. Option B, section 115A. Option C, section 116, and option D, section 114A. Question number 30. What should be the correct answer? 115, 115A, 116, 114A. Effect of holding over a lease. This is the heading of a particular section. So question number 30. Question number 30, again its correct answer will be C for Calcutta. That is section 116. Right? I hope it is clear to all of you. Now, yes, Vinny ji, you are correct. Now, before I move further, if you people have attended the session till now, don't forget to like the video and to subscribe to the channel. And tomorrow again we are going to meet up. Before that, I'm going to take up the doubt of Ankita ji. And moving further, if you people haven't checked out MP Civil Judge Prelims course, link is in the description box. Do check it out. Our live mocks have been started, और वो mocks past year question papers से भी बहुत ज़्यादा important areas को pick करके बनाए गए हैं. So you people will get a lot of advantage from those mocks. Don't forget to check out those mocks. Now coming to the question of Ankita ji, that was question number 20, right? So question number 20, principle of res judicata does not apply to. So if you will read the principle of res judicata, it is simply stated that the principle of res judicata is not applicable on the writ of habeas corpus, right? Ankita ji, I hope you can hear me. So the writ or the principle of res judicata, that is, once a suit has been heard and decided by a court of competent jurisdiction, then when on the same subject matter between the same parties, the same suit has been filed, that particular suit will not be dealt. That is by the former court, by the later court. This is the principle of res judicata. Now, the principle of res judicata does not apply to the writ of habeas corpus. This is what held by the Supreme Court of India in various case laws. This is particular question you can find if you are reading, like this particular thing is not mentioned in your Bayer Act, right? If you will read the commentaries of Bayer Act, or if you will read the books like Ashok Kumar Jain of CPC, or if you are reading like Takwani, right? For CPC, there you will find that the principle of res judicata does not apply to writ of habeas corpus, right? Ankita ji, I hope it is clear. Whatever you wanted to ask, it got clear. But in the cases of interlocutory order, like in the cases of the orders passed by the court regarding the arrest of the witness, arrest or attachment of the property of a judgment debtor either before the judgment or after the judgment, dismissal under order 17 rule 3, or any ex parte judgment, in all these cases principle of res judicata do apply, right? So I hope it is clear. Ankita ji, I'm waiting for your response. Just let me know, right? Sir, not to in the cases of ex parte judgment, also principle of res judicata applies. Here you have to understand what is the meaning of ex parte judgment, where one party does not appear after the continuous notice, and then after that the court continuously requires the appearance of that party, and after making reasonable endeavors to make the appearance of that party, that particular party being plaintiff or defendant does not appear, then the court may pass, like usually though the defendant does not appear, then the court may pass ex parte order, or ex parte orders may be res judicata apply hota hai, Ankita ji, right? So I hope it is clear. So thank you so much to all of you, and see you people tomorrow at 9 in the next discussion, right? I hope you people are enjoying the discussions. If you people are liking those discussions, don't forget to press the like button. And MP Civil Judge Prelims के crash course के लिए do check it out. Link is in the description. That is going to help you for sure. That I can assure you in person. After attempting those mocks, easily आपके 5 से 7 से 10 नंबर बढ़ जाएंगे for sure. In MP Civil Judge Prelims, exam is going to take place very soon. So get prepared for that, right? Somewhere in the month of April आपका exam हो सकता है. So be ready for that, right? Thank you, Ankita ji. Thanks to all of you. See you people in the next class.